at our focus, the Supreme Court has agreed to have a relook at their own judgment upholding the constitutional validity of the Prevention of Money Laundering Act. The top court will also review the powers of the Enforcement Directorate. The open court hearing will take place tomorrow. The review plea was filed by Congress leader Karti Chidambaram. Earlier, the top court in its July order had validated ED's powers to arrest, attach, search and seize. The apex court's July judgment had come under heavy criticism from the opposition parties, who pointed out the adverse long-term impact of the verdict.
The Supreme Court has agreed to list the review petition which was seeking for a reconsideration of the Supreme Court's original judgment on PMLA, which had upheld the stringent provisions of the Act, for an open court hearing tomorrow. The Supreme Court, by virtue of its earlier judgment, had gone ahead and upheld the stringent provisions of the PMLA, which is a special law which gives widespread powers to agencies like the Enforcement Directorate. On an earlier occasion, there were about 241 accused of the PMLA who had filed a petition in the Supreme Court, which was considered by a three-judge bench composition of the top court, which had said that there are enough safeguards already within the ambit of the law, and therefore there is no need to tone down the stringent provisions of the PMLA. However, subsequent to that judgment, a review petition was filed in the Supreme Court by Karti Chidambaram, and Honorable outgoing Chief Justice of India, Justice Ramana, has decided to list this particular review for an open court consideration tomorrow, which the Supreme Court will again hear. This is one of the rare times where the Supreme Court has decided to judge its own judgment.
All right, for more on this, I'm joined by Vivek Narayan Sharma, advocate of the Supreme Court on the broadcast. Thank you so much, Mr. Vivek Narayan Sharma, for joining us and speaking to Mirror Now. For the benefit of our national audiences, could you help us understand the significance of this hearing that is taking place? It's very rare because we know that ever since this judgment came the last time, there was heavy criticism, especially by the opposition, because the opposition has consistently claimed that the centre is misusing investigative agencies like the Enforcement Directorate, like the CBI. So for the benefit of our viewers, how do you view this development? Could you explain that to us?
The concerns expressed by opposition and various other parties, as your reporter had stated, that there were 441 accused in the matter. So they had all of them had filed a petition before the Supreme Court, challenging this particular various vagaries of the section 5, section 8.4, section 24, concerning the arrest, attachment, and then search and seizure, and also the power of taking possession of property without issuance of a formal order. So I was also representing one of the accused person, one of the person in the matter. So, of course, the concern when the judgment came, so the concern really spread across the board that if such plenary power is granted to the ED, then in that case, this power is capable to be misused. And in yesterday's hearing before the Supreme Court, Chief Justice Ramana, he had expressed that taking possession of property before the formal order is issued is capable for arbitrary application. So similarly, there are other provisions which have been interpreted in a manner which means much has to be done. And then constitutional validity, like fundamental rights of individuals, Article 21, the guaranteed rights. So whether they are infringed, the aspects have to be tested. And I think this matter is something which would require in future consideration by a constitutional bench.
Absolutely. And a lot of, former judges have also spoken about this. And if I may, quote a former judge who said that this must be reviewed. Former Supreme Court Judge, Justice L. Nageshwar Rao, he also opined that he might have taken a different view in this PMLA judgment. And as you yourself also quoted Chief Justice of India Ramana, he had also said that having perused the said judgment, we are of the opinion that the aforesaid ratio requires further expounding in an appropriate case. So it also, puts the spotlight on a sense of say if you can say that there's a sense of difference, there's a sense of distinction that the judiciary is trying to make as far as PMLA's misuse or ED's power, understanding the scope of ED's power is concerned?
Surely, see, law, whenever any law is made, it is based on the contemplation, what events might occur, how the law can be utilized for the benefit of the citizens, and any crime which may take place, how it has to be contained, and if at all the crime still takes place, then how the deterrence or the prevention has to take place. So the basic purpose of creating a criminal law. But now then, in that case, in the PMLA, the way the judgment has been pronounced, so for arresting a person or for attaching the property or for doing the search and seizure, no formal order is required as per the judgment. So that will definitely come in conflict with Article 21. If we even in the most open eye, it's without any deep scrutiny, if you look at it, that a person who has been stated to have committed a crime in relation to an action which comes under the PMLA Act, then in that case, without any formal complaint as well, the person can be taken into custody for interrogation. So I am of a firm belief that such a plenary power giving to the authority, whether the government of the day would want the same act to be done or not, but then the misuse of this particular provision in this fashion would be largely misused by the persons who are holding the authority directly at that point in time, without even the knowledge of the government also. So for that matter, of course, that balance has to be created. And then for creating that balance, this judgment required reconsideration. And I hope it is a step in right direction. But that review has been directed to be listed tomorrow in an open court. So let's hope for a better outcome in future. Let's see.
All right, let's hope for a better outcome. Thank you so much, Vivek Narayan Sharma, for making time and speaking to Mirror Now on this issue.